It's time for Big Issue here on New Day on TV3. And as we indicated, the main conversation today centers around issues surrounding the Chief Justice. And as you may be aware, the latest on it is that there has been an application that has been filed at the Supreme Court seeking to restrain the President and the Council of State from proceeding with the processes regarding the possible removal of the Chief Justice. We know that 3 petitions have been filed. As is provided by law, we do not know the individuals behind that petition or the content of that petition. But what we know is that the President is undertaking a consultation with the Council of State, and the Member of Parliament for Otafo Vincent Assefuah holds the view that some constitutional provisions have been breached as a result of the steps taken by the President so far. And so he wants the courts to put that on hold and have the court determine that aspect of it before they can proceed with it, if the court gives a clearance for that to happen. And I mean, there's a lot to learn from all of this, a lot of conversations surrounding whether the Chief Justice should be given the opportunity to even respond to the petition before the President consults the Council of State to make a prima facie determination. We know that the Chief Justice has also written to the President asking for a copy of the petition. And also she says that she should be given 7 days to respond to it. Now, what we are going to do this morning, we're going to have a bit of an education segment like I did indicate. And joining me for that part of the discussion on Big Issue is Samson Ladianyan, and he's a legal practitioner. And I must indicate that Samson was lawyer in one of the petitions that resulted in the removal of one of the appointees under 146 process. So he's familiar with that particular process, reason which we are engaging him this morning just to walk us through the various steps. There are various parts of the process that some may describe as gray areas. There have been some bit of judicial intervention here and there. He'll walk us through all of that. Samson, good morning, and thank you for joining us this morning.
Good morning, and thanks for having me.
I want us to start the conversation first by you walking us through the 146 procedure. And what I would want you to do is to let's just walk through the text as it is before the various judicial interventions that have made some modifications.
Right. So Article 146 is an accountability mechanism for a certain class of office holders, public office holders. And these are the justices of the superior courts, meaning from the High Court, Court of Appeal, and the Supreme Court. And this accountability mechanism, which is, first of all, a security or safety mechanism for them in their office so that they are not disturbed in the course of their work unnecessarily, is extended to independent constitutional body heads. So NCC, SHRAJ, EC, their heads are also subject to this kind of provision. So if you want to remove or impeach any of this class of office holders, the Constitution in 146 is very clear about it. You must present a petition, and the petition must be one that speaks to certain offenses that have been committed. The Constitution refers to that as stated misbehavior or incompetence or inability to perform the functions of the person's office by virtue of infirmity of body or mind. So that's the thing you need, the threshold you need to cross. Your petition must point to stated misbehavior that the person has so grossly misconducted themselves in their office, or that they have shown that they are incompetent for the job that has been handed to them, or that they are not able to perform the functions of the office because they are sick, or perhaps they are suffering a certain mental condition. Now, when the petition is submitted, it has to be submitted to the President. For all the independent constitutional body heads, for all the Superior Court justices who are liable, you must submit the petition to the president. The president, who is the appointing authority, so to speak, is giving the courtesy of being aware that the person you appointed is being considered, to be removed. And so the president's duty is what you call ministerial. And what's in my article in 2008, I wrote about this, I refer to as the conveyor belt duty. The president practically has no role in the process. His role is to be like a postmaster, receive the petition and forward it to the Chief Justice for the Chief Justice to make a determination whether there is a prima facie case. We'll come to that because that's a thorny matter now. Now, if it is about, when it goes, then the Chief Justice does the prima facie determination, and then the Chief Justice is compelled by law to set up a 5-member committee, which the Constitution prescribes who the persons should be. Then they will sit and hear whoever has been accused. They will also proffer their defense. And then when they are done, they'll do a report. And in the report, they'll make a recommendation to the president. The president is bound by the recommendation. He cannot vary the recommendation. He's bound by it. If they say the person has been found culpable and he has to be removed, the president has to remove the person. If they say the person is not culpable, the president cannot do anything about it. The role of the president in the process, where you can say is the active part that the president plays, is that once the petition, a prima facie case has been made, the president has the power to interdict or suspend the person who is being investigated pending the outcome or the final determination of the petition. Now, when it concerns the Chief Justice, the Constitution says the president will receive the petition and in consultation with the Council of State, make the prima facie determination. Once the prima facie determination is made in respect of a Chief Justice, then the Council of State, the President, together in the consultation process, and then the 3 others who are not supposed to be members of the lawyers and so on and so forth, then they will sit, and then the Chief Justice will appear before them, and then they will go through the process and make a determination. So there will be a committee consisting of 2 justices of the Supreme Court. One will be appointed by the president as the chairman of the probe committee, and then there will be 3 others who are not supposed to be belong to the Council of State. They should not also be members of Parliament, and they should also not be lawyers. So this is the process. And once they finish, they'll submit their report to the president. Once again, the president has no option. What the report says is what the president must do.
The prima facie determination, when it has to do with the Chief Justice, and what you referenced is the judicial intervention, because if you read the 1466, it specifically states that where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the president, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. And so for those who are reading, if you could just explain how that came about, because if you compare this to the 3, you see that with regards to the 3 for the other justices, there is that provision in the text for a prima facie determination to be made.
Right. So when it concerns anybody other than the Chief Justice, the Constitution is clear on its face, very plain, that the president should forward to the Chief Justice, and the Chief Justice should make a prima facie determination. Over here, when it's about the Chief Justice, as you have said, clearly the Constitution doesn't say that there should be a prima facie, but our courts do what you call a filling in of gaps. So this is a matter that the Supreme Court has had occasions to hear about and has given suggestions as to what may be the process to follow. So in 2005, a Judicial matter, and subsequently the Justice Utaderi matter, but that again is not, may not properly satisfy this. In Judicial, they were clear about it that, of course, you have to make a prima facie determination, and actually suggested that the president is going to do that with the Council of State. That job appears to be the job of a lawyer, and you may not always have a president who is a lawyer. The thing I'm saying was actually said by the Supreme Court. You may not always have a president who is a lawyer to be able to do this function. So they actually suggested that the president working with the Council of State, when they have to do a prima facie determination in respect of a Chief Justice, a petition against a Chief Justice, they could consult or hire a reputable lawyer to assist them in the process of making the prima facie determination. So there must be a prima facie determination. In fact, they said that the Chief Justice must be given the benefit of a prior prima facie determination. That means there must be a prima facie before you start, you set up the committee, just like it's done for other persons who are subject to Article 146.
One question that is coming up strongly, they said you are saying prima facie a lot. What does that mean to the simple man?
Right. So, prima facie, and what I often tell my friends is, don't allow us, the lawyers, to confuse you. Prima facie is Latin, but if you Google prima facie app right now, you will get the meaning. And guess what? I just did. And the Merriam-Webster dictionary says prima facie, that is something that is true, valid, or sufficient at first impression. At first impression. So the Oxford Law Dictionary, because we are talking about law, says that prima facie means evidence that is sufficient to discharge the burden of proof borne by a party, and that may be sufficient to discharge the persuasive burden of proof if no evidence in rebuttal is tendered. It says again that prima facie is evidence of a fact that is of sufficient weight to justify a reasonable inference of its existence, but does not amount to conclusive evidence of that fact. I need us to pay attention to that. So at the first point, it says, so prima facie simply means first impression. So someone has brought a document before you and says this document contains substantial allegations against somebody. You take the document and look at it. On the face of it, do they look weighty? Do they look like they are in trees? Somebody will say Bosremka. So you can throw them away. Do they look ridiculous? Do they look far-fetched? For example, if you say that Kofi Menu is in position to become a high court judge, and I look at the paper and I find out, I know that Kofi Menu is not a lawyer, First of all, that's something I'll throw away, because to become a high court judge, you need to have been a lawyer in good standing, and you must be at least a lawyer who has been in the practice for 10 years. So I would throw it away. But once I see, yes, Kofi Menu is a lawyer, okay, then it's becoming on the face of it that it could be possible. Then you say he wants to, he's being considered to be a high court judge. Meanwhile, he has done some really corrupt things in this place. Then we find out, okay, so the corrupt things you are mentioning, is this something that he's capable of doing? Is this something that is in his line of work when he was there? Is it possible? So you look at the prima facie on the face of it, impressions. Basically, that's really what it is about.
The subclause 6, the one you made reference to with regards to the Chief Justice, where the process concerns the Chief Justice. And the question is, because of the absence of a clear text by the framers of the Constitution, how is that determination to be done? Is it that the President is to consult the Council of State, they give him his opinion, and he decides, or he simply takes what they bring to him? And I'm asking in the context of various judicial pronouncements that seem to suggest that when the President receives advice, he's not inflexibly bound to follow the dictates of that particular advice. We know of the GBA versus the Attorney General, for an example, even the Justice Aban case as well.
No, this is completely different. This is completely different. This one, the Council of State and the panel, in the manner they act, the President is bound at each step. This is completely different. This is really not advice. The President is not bound by advice. This is not advice. This is a constitutional obligation to make a prima facie determination, which is done with them. So it is not done by it. It's done with the council. And the President is involved in the process. If you saw the last petition from Professor Asari,
yeah,
the prima facie determination that was made as communicated by the presidency, you will see that the presidency said this was done in consultation with the Council of State. And they issued the prima facie determination and said the matter was frivolous, and they didn't think it was weighty to get the attention of a committee to investigate the claims that were made in there. So in 2015, when I led Richard Nyama to in a similar process, there were several people who had filed petitions. It was not only Richard Nyama who had filed. There was an MP who had filed a petition. There were some others who had filed petitions. But their petitions failed because, very obviously, they didn't seem to have taken their time to plead their case well. Okay, so it was Richard Nyama's petition that was deemed to make a prima facie, and on the basis of that, the process, were gone into.
A direct question: in making that prima facie determination, would you agree that that is an exercise of discretionary power?
That's clearly what it is.
Okay.
And therefore, it will come under the bounds of Article 296, which, as it were, dictates how discretionary power should be used. It is a discretionary power that imposes a duty on the person who will give that discretion to be fair and candid in making that kind of whatever it has to do. And the boundary also, again, is that you are not supposed to be arbitrary, you're not supposed to be capricious, and you're not supposed to be biased, either by resentment or prejudice or personal dislike of the person that you have to make the prima facie determination about. And whatever you have to do the constitutional imperative in Article 296 is that you have to do it in accordance with due process of law. If a judge is the one exercising that discretion in the performance of their duties, it is not subject to too much question to a certain extent. But if the person exercising that discretion is not a judge, then the law says there must be rules, there must be regulation guide how that discretion is exercised. So, for example, when I led Okubako Jr. to the Supreme Court to challenge the process leading to the removal of Charlotte Osei, EC boss, part of my argument before the court was that, you see, there is a need for rules to guide how the process is done. In fact, in 2005, in the case of Ejay Chum, the Supreme Court, a number of its members, particularly Justice Sophia Kufu, then had insisted that there was a need to be rules to guide how the process is done. And so I raised all of these questions, and I remember telling the justices, about 5 of them, all of them asking me questions, interrupting me here and there. And I remember telling them that if they didn't ensure that there were rules, they themselves as judges were endangered, because the process is prone to abuse. We have seen in this republic that the politicians can abuse the process, you know, so they needed to do it and do it well. And even I said that, I was telling them, and I wrote in my submissions then, of course, the Attorney General then did not agree with me, that even what constitutes stated misbehavior, the rule should define it so that it's not at large and subject to, you know, abuse. See, in Charlotte Osei's matter, it was about procurement. So I was asking the question, I asked them the question, and I made an argument on it forcefully, that procurement, we have the procurement law. So if you breach the procurement law, there's a remedy in the procurement law for you to suffer. It shouldn't lead to you suffer the ultimate sanction of removal. Of course, they disagreed with me. Somehow they didn't consider my case in its full, Kokubako's case in its full. So sometimes it's difficult even speaking about it. So I said, if you do procurement, we know the politicians, they are doing procurement every day, and sometimes even do before they go for approval, and they get ratification. So if that was the case Charlotte, for example, was facing, in the Procurement Act, she could go for ratification, and the PPA will ratify the thing for her. In which case, she doesn't have to be removed from office. So is that a sin that should warrant her removal? We asked all of these questions, but it was not dealt with. I think at some point, this is where we will come to, where we have to provide plain rules to guide how the process should go. So you see, Parliament took a cue when they were passing the Special Prosecutor Act. See how they did it. You know, Special Prosecutor also goes through this process if you want to remove them.
Yeah.
So in the Special Prosecutor Act, they said, if the president receives the petition, within 7 days, he must forward it to the Chief Justice. If the Chief Justice receives the petition, within 30 days, the Chief Justice must make a prima facie determination. When the committee is set up, within 14 days, the committee should be able, you know, to be set up after the prima facie has been made. And then within 30 days, the committee should finish its work and present their report to the president. Apart from the Special Prosecutor, all the others, there are no such clear rules. And we need it. If we get it, it will help. Okay. The rules should say, for the CJ's part, that this is, even the prima facie determination, this is how it should be done. The CJ must bring her comments before it is done. Or should not bring her comments before it is done. We can do it that way. You see, the ones involving the other persons, The practice I have known is that the CJ will normally invite the person who has been petitioned against and ask them for their comments before the CJ will make the prima facie determination. But I know situations where those comments were not invited because, as you can tell, the views are divided, that you don't really need to hear from the other side before you make a prima facie determination, because when the case itself starts, you have the opportunity to be heard. We can use the rules to clear and clean up all of this and avoid the circumstance that we find ourselves in.
I mean, that was going to be my last but one question, but you've addressed that aspect already. So let me just ask the final one that has to do with the fact that there is a pending matter in court now. And we know you, the lawyers, you say that Nemo Judas in cause as well, you cannot be a judge in your own cause. But we understand that this case that has been filed that relates to whether the Chief Justice should be given a copy of the petition, we know that she has also written to the president to ask for a copy of the petition. So she stands, or she agrees with that view that she should be given a copy and allowed to make comments. But she will be allowed nonetheless to decide which judges will hear the matter, because that has been an area of some judicial pronouncements as well.
Yes, that's absolutely correct. The doctrine of necessity. There is no other person appointed and mandated to empanel the Supreme Court than the Chief Justice. For as long as the Chief Justice is there, it is the duty of the Chief Justice to do. I don't know if a Chief Justice will say, well, I want to allow the next person, the next senior person to me to do this. I don't know, but that's the duty of the Chief Justice, and you can't change the law.
Interesting. We'll leave it here for now. Samson Ladianyan in the legal practice. And I thank you so much for joining us this morning. Some great education taking us through the entire process. And as I did indicate, Samson participated in the one that had to do with the removal of the then Shraj boss at the time. And so he was lawyer for the petitioners. He went through that entire process. That is how come we brought him in to walk us through some of these issues and deal with those matters. And I mean, the last point we were making was that, I mean, on Wednesday, the case will be heard whether the President and the Council of State should be injuncted. And you heard him explain that under the doctrine of necessity, the Chief Justice will decide which 5 or 7 judges will sit and decide whether that should be, the President and the Council of State should be restrained from dealing with it. That's what the law provides for. But I can now bring you into the studio. My guest in the studio, Abraham Amaliba, is a legal practitioner, is Director General of the National Road Safety Authority. He's joined us in the studio. Next to him is Ebo Bachman. He is a senior communicator with the Movement for Change. He's also into financial and economic analysis. And next to Ebo is Professor Enoch Opoku Entry, who is a governance analyst. Gentlemen, thank you for joining us this morning.
It's always a great pleasure to be here.
Yeah, I'm sure before you ask, there's one person who is not available, you know. So today, no one will disturb me. We'll have a peaceful interaction. We'll miss him. Yeah, we'll miss him. He's had a bit of emergency this morning, so he's unable to join us. Our own uncle, Kwame Janto, legal practitioner, energy analyst, is always with us on Friday, bringing us very interesting, varied perspectives and asking questions. He's unable to join us this morning, but who should I start with?
I should
start with you.
Yes, good morning to all your great listeners. I know Ghanaians love TV3 a lot, and we're always happy to be here. I think this is our national service, right? Yeah. Voluntary service that we do for the country. This issue is quite complicated, but history keeps repeating itself. You know that when Charlotte Osei was being removed, she also asked for the petition to study so that she can also respond to it. For me, on a layman's view, I'm not a lawyer. This issue is very clear. If you go to Article 146, 6 to 10, now I want to read it because law is an authoritative, course. What it means is that you have to quote it verbatim. Now I'm going to quote it. It says that where the petition is for the removal of the Chief Justice, that is 146.6, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. That is 6. And then 7 says that the committee appointed under clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. Excuse me, that is 7. All proceeding under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in defense by him or herself by a lawyer or other experts of his or her choice. And then 9, the President shall in each case act in accordance with the recommendations of the committee. And the last one is that, which is the 10, where the petition has been referred to a committee under this article by the President, I'm talking about from the 6th, in case of the Chief Justice acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the Chief Justice. These are clear, very clear. So when the President is petitioned, and I'm not bothered by the Chief Justice saying that she wants a copy of the petition. Maybe she wants to study, because in the process, what it says here in the Constitution is that she will have to respond. So she wants to know how it was drafted so that she can respond. I don't see anything wrong with that. The President will appoint 2 justices and then 3 other individuals who are not members of Council of State, who are also not members of Parliament, and who are also not lawyers. So we're looking at something like a jury, people who don't have prior information about the issue, just to help the 2 Chief Justices, the 2 justices appointed. So we have a 5-member committee. Now the question is the Chief Justice ought to be suspended or fired? That is the biggest question. And that we go to any misbehavior, any other thing that might have caused. Remember that even the President, if the President is incapacitated, if the President is not of mental sound, the Constitution says that we can remove the President. Then it says that it will be held in camera. That means we're not going to see how the process will go. Why? I don't know. So some of these things are case studies. That moving forward, that we have the Constitutional Review Committee, we should be looking at some of these things. In
fact, the question of the in-camera, in one of the cases, Justice Derry versus Tiger Eye, the court explained that because of the sensitive nature of the position they hold, and so a petition can come up and in the end it may not go through. They may be cleared of the charges. But if you put it out there in the public domain, you risk all of that becoming a subject of public discussion, and if it doesn't go through, the person stays in office and the reputation.
I disagree. I disagree entirely with that, because who is the President for? It's for Ghanaians. In fact, power actually in any constitutional country belongs to we, the people. So if something borders on the President, if something borders on the Chief Justice, if something borders on the Electoral Commission, if something borders on the Office of the Special Prosecutor, and all of these guys are, protected, why should it be held in camera? We should know what is going on. If a case, is filed against you, and then we cannot find or determine any prima facie against you, why should that be held in camera? It should be open so that everybody will know what is going on. When everything is open, I think that nobody will sit somewhere and think that there's a bias somewhere. So the President is following the process. What we know is that he's forwarded it to the Council of State, which is the first step. Now, I've also seen that Vincent Desifua has also filed, he has sued. That cannot be done. Let's see what the lawyers do, because AB is a lawyer here. It's going to be back and forth. Lawyers, I put it to you, you put it to me. Those things are going to be going on. But we have to follow strictly what the Constitution says, and I think that it will bring finality to it. Professor,
you did indicate you're not a lawyer, but the point that I left off with something that had to do with the fact that the case that will be heard on Wednesday, it says under what the law provides for is that the Chief Justice will still have to decide which 5 of her colleagues will sit and decide whether the process should be halted or not.
Yes, I heard that. That is wrong.
What do you mean?
That is wrong. Because if a case is filed against me and I have to select 2 individuals to go and represent me and talk about the issue, of course, naturally, I'm going to select people who will go for my side. So that part of the Constitution, we should amend it. Because if she determines everything, I'm going to pick you because I know you have my back. I'm going to pick a boy because I know he has my back. What about the others? The same situation we have in empaneling even our judges, Supreme Court judges. Because the U.S. Constitution says that the maximum should be 9. 340 million population, the maximum of our Supreme Court judges is 9. We picked the U.S. Constitution, part of it, and we said that our minimum should be 9. So we have over 17 Supreme Court judges, and anytime there's a case, we are empaneling 5 or 7. But the Chief Justice empanel them, and you see that some people will be sitting there and they will never be empaneled. Why? Because it's human tendency. They are human. And you pick people you think that they will go for your thought, what you are thinking. The same way when we are hiring people, even at the workplace, we hire people that we think will fit into our culture, which I also think is wrong. Because if you're all thinking the same, then nobody's thinking.
I mean, Ebo, how do you process all that we've seen happening right from the very initial statement that came from the presidency indicating that, look, they are consulting with the Council of State? I mean, there are those who already are reading a lot of political undertones with all that is happening. Because when Charlotte says, the former EC chairperson, when she was removed, I mean, we had individuals who boldly stated that this is not the last time we've seen an Article 146 process.
I thought you were going to go to a lawyer before, so that I can glean from whatever.
I'll stay a bit.
Yeah, I can glean from whatever.
That's why I decided
but
the foundation for us first.
Yeah, but it is important. I greet this morning. I greet our viewers, my colleagues here, and your good self, and your crew here. You see, why are you all pretending that this is not political issue? We are talking as though this is the only legal issue. This is political issue, and to be honest with you, in this duopolistic United States political system that we have, whether we like it or not, we have at the moment, some of these things are bound to happen, and so when they do happen, yes, the lawyers can look at the legal aspect of it, but then if you also look at the issue critically, of course, is the issue of politics as well, because if there's political appointment, then there's bound to be political disappointment. I mean, this is something that has been happening in our country. It won't be for the first time that somebody who has been appointed by the president, by the previous president, will be disappointed by the current president. So, but from my layman's point of view, I've been asking myself certain questions because, as you rightly pointed out, Vincent Asafo has taken the case to court, asking that the case should be struck out or something like that. I don't know your legal...
First, he wants it to be put on hold with regards to the processes because he believes that the Chief Justice should be given a copy of the petition for her to make comments before the President consults with the Council of State. Yeah,
but you see, I mean, from a layman point of view, because yesterday I read the Constitution. I really don't have the legal brain like that, but a common understanding, the Constitution does not mandate the President to do that. That is one thing. And maybe in light of the principle of natural justice or maybe procedural fairness, the Chief Justice will have to be given a copy. But the question is, at what point in time must she be given a copy? Should it be prior to the President consulting the Council of State to establish or to determine a prima facie case, or after that? But if it is given to her before the determination of prima facie, and upon determination they realize there is nothing at all for her to answer, then why was she given it in the first place? So I believe that if there's going to be a situation where she will have to be given the opportunity to know what is contained in the petition so that she can prepare for her defense, I believe it should be after the determination of prima facie, so that at that point in time, you know that she really has some questions to answer. So that is my layman's understanding of the issue. And the issue that Prof, you brought it up, Prof also mentioned, I don't understand why somebody is involved in a matter. When issues of that nature happen in our courts, we hear judges say, I recuse myself because I'm directly or indirectly linked to the issue. But this one, the Chief Justice herself, who is a prime,
in fact, there have been, I readily remember two of judicial pronouncements in that regard. The courts have taken the view that it is an exception to the rule on you not being a judge in your own cause, in that she's required under law to do the empaneling.
Yeah, but that is where I have a problem.
It is wrong.
I mean that is where I have a problem.
It's wrong.
You see, one thing I'm happy about is that all these things are happening at the time that we have a committee looking at our constitution, the Constitutional Review Committee. This provides a fine opportunity for the committee to take into consideration all these things that are happening lately concerning legalities of issues in this country. The whole thing is that, to be fair with you, to be honest with you, the whole thing is politics. And let's not make noise about the legal aspect too much. It's politics. If I were the Chief Justice, I will resign. I'm telling you. So that we cut all these things. I mean, it is politics. I mean, the fact that you are appointed by the previous the president, and certainly every president would appoint someone who is loyal to him. So the question is that maybe the president is not comfortable with your loyalty. Maybe some comment or something, some information, something.
Is it not in the interest of all of us that the president should not be necessarily comfortable with the Chief Justice?
No, but the point is that
that is where you want to go.
But the point is that, you see, that is why prior to the election, for example, we said, the Movement for Change, we said that henceforth, I mean, we should look at the Constitution so that the president will not be the one to appoint Chief Justice. The president should not be the one to appoint electoral commissioner, to appoint IGP and all that. Because if you give the president that power, the president will certainly go for somebody that he can trust. And if my opponent can trust you, then certainly it will be difficult for me to trust you as well. And that's why I'm saying that, yes, the lawyers would want to, especially if you look at what is happening, the reason I'm saying it's too political is that it's like the MPP wants to protect its own. I mean, the Chief Justice is our own. So let's go to court. Let's do everything to protect the Chief Justice. And on the other side, the NDC. So I mean, we can't trust it. I mean, this is we can't trust it. Let's also go through the process. The whole thing is that they will use the law. The same thing was done to Madam Charlotte Osei. And
you are saying, as far as you are concerned, you think the Chief Justice should resign?
No, if I were her, I would resign, because I mean, she finds herself in a system, a political system, the winner takes all system, that lends itself to some of these things. That once you are appointed, you are a public official, and you are appointed by the president, then it stands to reason that the next president would also have to find a way to get you out, because even though you're operating a system, a separation of power system, where each arm of government is supposed to be independent of each other, there's also checks and balances. And so if the president is allowed by the Constitution, or if we are, as Ghanaians, we are allowed by the Constitution to petition the president about the conduct or otherwise of the Chief Justice, and the president can go through the procedure to get the Chief Justice out, why not? Because that is the system you have. But if you can have a system where the president has no say, has no control, has no manipulation in respect of the appointment of Chief Justice, then we can be sure of the tenor of security, the security tenor of the Chief Justice.
So you think it's because of the appointment process, that is how it fits into the mistrust, which has resulted in the parties wanting to change the individual?
Yes, because we are talking about politics, and the fact that the person was appointed by a politician, then don't be surprised if another politician wants to get the person out.
Let me come to Mr. Maliba now. I mean, Mr. Maliba, first, your general impressions about all what has transpired right from when the statement came from the presidency about the consultation taking place.
Well, am I surprised? I'm not surprised, because this same Chief Justice, even under Akufo-Addo, there were petitions against her. Will there be petitions against her under this administration? Did I suspect that will happen? I suspected that will happen. So I'm not surprised that this petition is coming. What I'm surprised at is the legal sophistry that lawyers for the Chief Justice are engaging. And I call it legal sophistry because they know clearly under the rules, the Constitution, what they are talking about does not exist. They know. So the sophistry is that let's just throw and sprinkle one or two things in the Supreme Court and hope that it will catch. Because those there are our appointees. So let's do this and see whether it will catch. Because both lawyers and the Chief Justice herself are running ahead of themselves. It's about the petition that she wants to see, isn't it? But it is premature now. It is premature. Because even in her case, when she is a Chief Justice and a petition is referred to her, she's not obliged to determine whether it's a prima facie case. She's not obliged to give the petition to the one who is the subject matter of the investigation. I listen to what I'm saying. Even here, when a petition is referred to her to determine whether it's a prima facie case or not, she's not obliged to hand over the petition to the person who is under investigation. She's not obliged. Even here, if another superior court judge or Supreme Court judge is under investigation and she has the power to determine the prima facieness of the case, she's not obliged to give it out. That was said in the Utadere case. You get my point? Yeah. But you also ask, and I'm a teacher, so I like to make things easier. You ask for the explanation of prima facie. When I teach my students, I tell them a prima facie simply means that upon examining the case, you have a case to answer. That's what it means. That's all. You see how simple I've made it? After examining the case, or after examining your case, so Akabile, a matter has come, and I'm to determine prima facieness of the case. After examining the case, I think that you should open your case. You should talk. That's all. Is it not simple? That's prima facie.
I mean, you made reference to the point about the fact that when it has to do with the other Superior Court judge, she's not even obliged to extend that. When you read her letter to the president, she takes the view that in those instances, she thinks that the need to act fairly requires that one is heard in that particular manner.
Yes, but she will still have opportunity to receive a copy when the committee is put together. The issue is this. Let's ask the question. Has her rights to be heard taken away from her? That's all.
I mean,
let's give the answer to the people. No. The answer is no. Because she would have opportunity when the committee is put together and she'll be given copies before she appears before the committee. So that right has not been taken away from her.
I mean, the question to you will be that if she is not heard on whether before the determination, the prima facie determination is done, so there's the possibility that someone on face value could cook up various allegations against you. Allegations which, if you see on the paper, you'll be like, wow, this one, we have to look into it. Whereas, if at that stage, you simply had the benefit of initial responses, you could quickly realize that, well, this is no issue.
No. So you don't know what? I think what she should be asking for, in terms of fairness, is that she should be given ample time. Are you listening to me? She should be given ample time to respond to the petition. She should be talking about that. Because even in her own, was she the one? No, Utadere she wasn't the one. Utadere was Georgina Wood, I think so. Utadere.
Yeah, but in terms of the case, the decision, Georgina Wood at the time, but the decision that was by Justice Benin in terms of the matter that went to the court.
Yeah, but in the Utadere case, Utadere's argument was that I was given time, but the time was not enough, or it was not up to the time for me to present my response, and they went ahead. And the court said that they didn't even need to do that. Are you listening?
Yeah.
That they didn't even need to do that. At that stage of determining whether there's a prima facie case or not, they didn't even need to do that. So I'm saying that they are running ahead of themselves. I'm saying that it's premature ejaculation at this point. I'm saying that it is a case of they trying to behave like they are sorcerers. You know a sorcerer? A sorcerer in my language is a bakologo. They are a sorcerer. When your child is sick, you go to your child and say, oh, I want you to see whether my child will die or not. And then the sorcerer will try to say, oh, the child will not die. But this is what I'm talking about, that they are engaged in sorcery. The time will come for her to respond. And I think that they are simply running ahead of themselves.
Does the process lose anything if a hearing is extended at this stage?
If she's giving the petition at this stage, because it is not borne out by the law, we are men of law. Not men ruled by other men. We are ruled by law. So if the law doesn't say that, you should provide her with that. Look, what we were in this country when Charlotte was writing copious letters, even in a case, the prima facie determination was done. In Charlotte case, the prima facie case was done. And the president's spokesperson, Eugene, says he is surprised the lady is asking the president to give her a copy. That's how they ridicule her.
Yes.
So I'm saying that it's not borne by the law.
I mean, they will point to the fact that this determination is basically discretionary power that is being exercised. And under 296 and 23 are supposed to be fair and act reasonably. And the court has in various decisions said that, well, if you, in acting fairly and reasonably, it includes giving a right of hearing.
Acting fair, reasonably, must be borne out by the law. You don't go ahead of the law. The thing they are talking about, does the law provide a solution? Yes, at the committee stage. I will come to the defense of the Chief Justice. If at the committee stage, they put up the committee and they give a very short time to respond to it and then appear before them, I would support her. I'll come here, I'll let you invite me, and I'll say it's wrong. But for now, she should understand that these processes are just rolling out. And she can get a copy and look at it. I don't want a situation where it will look like she thinks that she's being targeted. But even if it is that, look, this Chief Justice brought all this upon herself. Look, as Director of Conflict Resolution, I was invited to be part of the signing of the Peace Pact in the Kempinski Hotel. She was sandwiched by President Mahama and Ibn Chambers. This woman sat like this, turned her face like this, just like this, throughout the program like this.
But I mean,
No, I'm just saying that.
She didn't want to talk to you.
Yes, it can be petty. It can be petty, but I'm saying that. No, wait. Let me tell you. It can be petty, but I'm saying that. Listen to me. It can be petty.
This is an observed phenomenon, right?
It's an observed phenomenon.
Yes.
In research, we do that.
Yes.
I'm saying I was there. She turned her face this way throughout. Now, my point is this. If today President Mahama becomes president, these petitions were not triggered by the president. People brought them. When the president said, I told me lying. When the president said, I told me lying. So, part of what is happening to her now, and this is a lesson to all appointees.
But substantively, your point about you saying that she has brought it upon herself, outside that observation, I get you to suggest beyond that her tenure, you have concerns with that.
Well, the petitioners would have to state that she misconducted herself, she's incompetent, and then she's not fit to hold office. These are the two things that the petitioners must show. If the petitioners are not able to overcome this threshold, the petition, like you said, will not go anywhere. Right. So these are the two. The third one is that she's incapacitated, and we know that one is clear. We know she's not incapacitated. But these are the two bases: stating misbehavior and incompetence. So it is for the petitioners to overcome this threshold, and then she will now have the time, opportunity to then respond to them. I mean,
one issue that went around the table had to do with the exception to the natural justice rule. I don't know whether you agree with. As a lawyer, if I'm a lay person, I would agree with them. But as a lawyer, I know that if general rules are made, there are exceptions to the general rule. So, for instance, a general rule can be made that everybody must bath in the night before going to bed.
Which is important.
Which is important. But there will be an exception that those who have chicken pox should have a no bath. Are you there with me?
Yeah.
So you see that I'm teaching today.
But honestly, this is a very bad exception.
So I know that in law there are general and there are exceptions. So because of that, but if I were on the streets, I will agree to them that it is unfair to be a course in to be a judge in your own course.
Yes.
But even there, because there's an exception, I can live with it. Yes.
But it's a very bad exception, to be honest with you. It's a very bad exception. Because if others will have to recuse themselves, even when they are not so much connected to the process, they will have to. This one is directly involved. So why would she be? Should she be the one to empanel judges for that?
I think the challenge we have here is that people are so much energized by power, and the way people like power here, I don't know. Power do not belong to the executive or the legislature or the judiciary. It belongs to the people, and you hold it in trust for the people. So when it comes to a time, you just came to serve. And there will be a time you have to go. She's not be the first Chief Justice, she'll not be the last. I know in US there was a Chief Justice, a Supreme Court judge, because the husband was sick, she resigned to go and take care of the husband. So people do things. I know professors who, because the father was sick, left as vice president of universities just to go take care of their family. Because family is number one. But here, power is everything to people. And power is not like that. You are just a steward. And at a certain point, you are not the first president, you will not be the last. You are not the first Chief Justice, you will not be the last. You are not the first speaker, you will not be the last. So let's hold these in trust for the people. The other advice I have is that if you look at Article 5, even those in the forces, the police, the military, the immigration, they are not supposed to be partisan. But you'll be surprised to know that some have MPP card and then NDC card. So they meet a big person from MPP, say, oh, I'm a member, this is my card. They meet another person from NDC, I'm a member, this is my card. Why are we doing this to ourselves? Because of what they both said. It's the winner takes all. So when you are no more in power, somebody comes and then they fire everybody and then they bring their own body. It doesn't help. We should move away from this to understand that after 68 years, a change in political party does not necessarily mean that somebody should lose their job. And that is because you are not supposed to be partisan. So when you talk about exceptions, I will talk about outliers. Exception means that if you are making policies for organization, and then we say the CEO is an exception, so he or she can do whatever they want, then it becomes problematic. But if we are all under the rule, which is rule of law, equality before the law, it helps a lot. My challenge now is that if you allow the Chief Justice to empanel 2 justices from the Supreme Court, of course we have other 3, God being so good, who are not supposed to be members of parliament, who are not supposed to be chief justices, they are not supposed to be lawyers.
So the empaneling is in relation to the case that will be heard on Wednesday.
Yes.
With regards to the 2 and the 3, that one the president will do that.
Yes. But I like that process, because now the 3 is going to be more than the 2 that is coming from the Supreme Court, which even if they are voting, there will be 3 against 2. But what I like with what AB said was that we should not, and again I repeat, we should not start judging cases when it has not started. The whole case has not been started yet. We don't have the committee yet. And if you look at what I read from the beginning, the committee is supposed to determine what but my worry was the in-camera. Let's make it public so that everybody will hear.
I mean, Prof. Ebo made a point earlier about the appointment process, and he thinks that if we make changes to that, especially now that the constitutional review process is ongoing, that could sometimes avoid the controversy that surrounds these appointees. Because, I mean, it simply means with the current arrangement, the government of the day would not be comfortable if they did not appoint the person.
I don't think we make a constitution for government to be comfortable. That's not the meaning of constitution. The spirit and letter of every constitution is to make sure that everybody in the country is comfortable. And I keep saying this, that the law is the least bar of every country. The highest is morality. The highest is morality. So if you have the moral uprightness, not to steal, not to take somebody's wife, not to, do the right thing, you don't know where the law is. I've stayed in many countries abroad that I don't even know where the police station is because I do the right thing.
So morality is the highest, but that is why when you break the law, you go to jail. Because the lowest bar everybody should clear to live in a society. And we should be looking at morality instead of looking at the law all the time. Because I see from the media, every time what does the law say? We have lofty ideas in our law, but implementation has always been a problem. I don't think we should change the law in the middle of this issue. But I think that moving forward with the constitutional review, we should be looking at some of these things and make things clearer so that even people who are not lawyers or judges can just look at the case based on the Constitution, which is our book, the book that guides us as a country, so that we can make simple decisions.
I mean, but there are those who blame you, the politicians, for this kind of situation we find ourselves in. I mean, one side not comfortable with what is ongoing, one side also saying, well, she has to go. And the point they make is that when they are out of power, you don't simply trust government officials, even normal civil servants. You don't even trust them to even act fairly. And so you are the ones who are to blame. I mean, why should anyone worry about who is the Chief Justice if our systems are working properly and the matter goes to court and judges who, very experienced lawyers who have risen to that level are sitting on it? We should be comfortable.
Yeah, you see, it is not only the appointors who are to blame. The appointees themselves also have to be blamed. Because, you see, when you are appointed as a public official, your fidelity is supposed to be to the state. But if you are seen at any point in time, you are seen to be more loyal to your appointor instead of to the state, then some of these things are going to happen. Until we, the people, decide to amend our constitution to sort out some of these gray areas or lacunas or
the nuances
in the constitution, until we, the people, decide to change our political system. If this winner takes all system continues, I'm telling you, these things would continue to occur. The only way to cure this is to have a constitution that is able to cater for all these things. And that is why I'm excited that I've always said that. I don't know whether you've taken notice of it. Since we put together this Constitutional Review Committee, a lot of issues have come up that require some constitutional amendments. So, probably we are at a place or in a place or at the right time.
We are in a good place at this point in time.
To get some of these things sorted out. And I want to repeat it. This is political. She's going to go. She shouldn't fight so much. She shouldn't resist it so much. She's going to go. I mean, if I were her, I would rather resign.
You have not seen the petition.
No, I'm saying, but you see, no.
You don't know what is in the petition.
I mean, you see, this is politics. You see, the lawyers would always ask for business for whatever is doing is neither here nor there. He just wants to be in the picture. He just wants to be in the picture.
That's a member of parliament.
Oh, my brother, he just wants to be in the picture.
Constitutional provisions being implemented.
No, because I mean
that when you have concerns, come to the court for us.
No, but I mean, he's also being political. He's using the law to be political about the issue.
So
I mean, that is
how do we step away from the politics, David?
You see, I believe in one thing, which is that you do me, I do you. Then we'll all now come to the...
You believe in that?
Yes.
No,
the Mosaic law. The Mosaic law.
He said that. An eye for an eye will need the word blind.
I'm coming.
You see some interesting ways here.
The Mosaic law.
You do me, I do you. Then we'll all then come to the table and say, look.
Ceasefire.
We know both is not good. You know you do, I did, it's not good. But if one side is vindictive when they come to power, and the other side always say, Father for all, Father, it will continue. Look, Akufo-Addo came, remove, Charlotte said, the person who made you president, who declared you president. When the declaration was done, he didn't mince words. He didn't announce the results twice, 3, 4, 5. He gave it to you. Appointed by Mahama. From there, you remove Dominevo.
Editor General.
So, were there no elders in that party who would tell Akufo-Addo, stop doing what you are doing? Now, what I'm happy about, what is happening now is that in the unlikely event the MPP comes to power again, when there's a person who thinks like Akufo-Addo and is leading them to be president or is the president of the country, now elders in the party say, hey, Jai Sao, and yet, then there will be peace. So my belief for you do me, I do you is a temporary measure to bring about, some rapprochement. Rapprochement. Else, it is not proper, it is not good that I always remain the punching bag. Do you understand that? Even in our childhood days, when somebody is always attacking you, don't you one day stand and say, all that, let's do it? And then you end up even beating him. Do you know? Have you seen that situation? Yeah. There's a guy who will always be worrying you in the area.
A bully.
A bully. Then one day it comes to your neck. You say, I can't take it any longer. Then you stand up against him. That is the day you get your freedom.
I mean, I get you suggest the point Ebo makes that this is purely political.
Well, I don't know whether it's politics or it's not politics.
In fact, some have pointed fingers at your party, the NDC.
Say what?
They make the point that the presidents in the run-up to the election had cause to, on a number of occasions, complain about the fairness of the judiciary.
Okay, now.
That is a statement of fact. You agree?
It's a fact. Even when I was director of legal and I organized NDC lawyers, that was my baby. And the president would come and address it.
Yes, I remember.
On several occasions, events, yeah? He'll make mention of that. But think about this. They are saying that they want to hear the matter on Wednesday. I'm sure they would have sat on Monday, but because it's a holiday.
Yeah, Tuesday is a holiday as well.
Quick one.
When the NDC filed to stop the e-levy, did they give us a quick date? Does this not call for a reform in the judiciary that handle all cases equally? This is an example. So when the current president, who was the former president, was making those statements, former president, as he then was making those statements, it was because of some of these things that we are seeing. And when you look at the Afrobarometer report about the judiciary, it's all about corruption and that they are up there with the police sometimes, competing with the police. We know the police there, we know. But for them to also be competing with the police, it's a matter that is of a great concern. Because the courts are the last places that we all go.
Yeah.
So when somebody is asking for reforms, it's not that he dislikes the judiciary, but he's saying that we must have things done properly. And you benefit. Because when things are done properly, you will not think twice before going to court.
Yeah.
So I think that this is not political. This is about...
Oh, the way you started off, it sounded like it was political.
How? I didn't say that.
No, I mean, the way you started off about the do me, I do you.
Oh, yes.
You had agreed.
I do me, you do you is like, say, it appears the NDC that is always at the receiving end when government changes. But we need to also stand up against them. So if this is one of it, so be it. But I think that the comments made by the the current president is difficult to...
Yes, I mean, multiple capacities over a short period.
Former president, as he then was, is that we need reforms. And I've given an example of reforms. Why do we need reforms?
Yeah.
Why would some cases not be heard till the tail end of a regime? Then you now make a pronouncement and it becomes odious. That requirement, that pronouncement will not affect the government again. We have a lot of those cases.
I think even in terms of the expeditious hearing, people made reference to the Afenyo Marking case.
Exactly.
I think the decision was by the speaker was on a Thursday. By Friday,
yes.
There was a hearing.
So those things.
What about that?
Those things. So you need a judiciary that will be fair to everybody. Even in the empanelling, when there was a known MPP person on a panel, that person should have just recused himself. You know?
So we need to fix our empanelling system.
We need to fix all these things.
The problem is.
You know?
I mean, just a final round on this one, and let me start with you, AB, still. I mean, what are your expectations going forward?
Oh, my expectations are the President and the Council of State will do what is needful and determine the petition. When they determine the petition, they should quickly let us know whether there's a prima facie case for her to answer. And then they should quickly also give her the response at that stage. That stage, I don't want to be hearing the Chief Justice saying that she wants a copy. They should just give it to her and then put up the committee and then we'll see the final result.
I mean, if the committee is to be set up, there's the power of suspension as well.
Oh, yes. Yes, so that one is at the discretion of the president. Whether there are instances where some presidents have allowed the person who is under investigation to continue to be there. I don't know whether Lamte of she continues to be there, until the final determination. So it's at the discretion, and this president has done it before.
I mean, but what do you expect to happen?
Let me use this opportunity to advise, my humble advice to the Chief Justice.
Another one, you've already told her that if you were here, you step aside.
No, first I said if I were here, this time I want to say she should resign. I mean, to avoid all these legal gymnastics, politically tainted legal gymnastics going on, we need to avoid all. If I were here, yes, but this time I'm advising her to, humbly advising Madam, kindly resign.
Well, I think we should all dare to be humble in political positions. It is not permanent. It's there to serve people. And what is going on here, we should all learn a lesson from it. I think that anytime we are appointed to positions, we should handle the position in just neutrality. This MPP, NDC things, and it makes things difficult for any new government to come and then continue with their policies and then their projects and programs. Because people are there in the civil service that you cannot even trust. Now, whether you like it or not, when the government changes, you are supposed to work with new government administration. And your political party doesn't matter. Here, we banter too much about MPP, NDC, and when MPP comes, almost everybody in NDC, some they will not even allow to go to the office. They kick them away. When NDC comes and they do the same, people will talk about that. When is it going to stop? So that we make professionals professionals, technocrats, and then they become neutral and work with any government that comes to office. That is where we should arrive after 58 years, 68 years of independence.
Well, we'll see how that goes. And so that is it by way of our first discussion. And earlier, I engaged Samson Ladia, and a legal practitioner, to walk us through the process.
And during the Peace Council even endorsed the removal of Charles there. Peace Council.
Yes.
Even endorsed the removal.
But we have former Chief Justices and all those people at the Council of State.
Yeah, they can determine.
So they can determine this easily.
Yes, sir. And so earlier, when Samson was speaking, he made reference to the removal process for the special prosecutor, and he had indicated that it takes 30 days for the conclusion. It's actually 90 days, and he's indicated that it's actually 90 days, and that was a slip. And so take note of that education segment. It should be 90 days for that completion process. And the point he was making was that it's necessary for some instruments to be in place to guide that particular process. So that is it by way of our first discussion. It's an unfolding story. I mean, it's one that between now and Wednesday, we don't know what may happen, whether the president will take any steps, whether the Council of State to complete the process, whether because of the pendency of the application they're going to hold on. All of these are matters that we are going to bring you the latest on in the course of
I'm seeing another petition. Niaje do petitions President Mahama for removal of Justice Gabriel Palmer. So we'll remove all of them.
Somebody sent me something from Netherlands. Say Anabila to you something. He said, "You do me, I do you."
Well, we'll see how all of that goes over there.
You don't need to pretend.
But that is it by way of our first discussion. I mean, the second issue that we'll touch on.
That is terrible.
We'll try to make sense of. It's a very disturbing situation. It has to do with some containers at the ports belonging to ECG. I mean, if you want to trace the story from the beginning, it gets very confusing because from the onset, we were told that in the first place, ECG had procured items that they didn't even need in the short and medium term. So there was excess of procurement, if I'm to put it that way. And now it even turns out that the quantities that had been indicated as what was at the port had fallen short. Some of the items had been stolen, basically. And National Security undertook some operations. They've been able to arrest some individuals and seized some of these containers. And already people are raising issues about the security system, because I know people who go to the ports and they say that it's a place where it's very well protected. I mean, it will take a lot more than someone. It's not something like walking into a place and just picking a pen or a paper. I mean, these are containers. How do multiple containers get taken away in that manner? And those are cables on your screen, very expensive cables, we are told, that have been brought into the country. But National Security have been able to act swiftly. And let me start with you, Prof, once again on this particular issue.
Ebo, I am devastated. We live in a country where if you don't steal and you lead a righteous life, people think, say, wow, I'm obra. Those who steal and nobody cares how you made the money are those the people that society respects, which is very pathetic. Now, Mahatma Gandhi said there are 7 things or 7 sins that destroy any nation, and I'm going to list them. He said politics without principle, wealth without work,
knowledge without character, commerce without morality, pleasure without conscience, science without humanity, and the last one is worship without sacrifice. Gandhi said these are the 7 sins that destroy any nation. And if you look at the first 4, we are there as Kenyans. Politics without principle, wealth without work, knowledge without character, and then commerce without morality. Everybody sells things the price that they want. Anywhere, we don't have price control, so everybody sells everything the way they want. So the same thing you buy at this price, you go to another shop, it's a different price. That is commerce without morality. We have people who are into politics without any principle, but the only principle is to make money. We are talking about at least 40-footer containers, not cell phones, not cell phones, but 40-footer containers that have been stolen. How were they stolen? Now, let's talk about 1,300 missing. 1,300, not even 1 or 2 that we say is a mistake. 1,300 missing. And 40 has been found at pawn. 40 has been found at pawn. And it was bought by an Indian guy. And he said some guys came and sold it to him. So if you buy a stolen product without due diligence, you are also culpable, according to the law. Now, they were meant to be cleared at the Tema port. So security operatives were there, the intelligence people were there. How did they slip? All these cables slip under their care. ECG has a problem. They now have a debt of 9.6 billion Ghana cedis for us. We're talking about prepaid meters. You go and pay before you even use it. And look at the debt there. You prepaid, you bought before you use it. You have to buy 200, 300, 400, 500 before you can put the number, the code onto your meter and use it. So you pay before you use it. And look at the debt. Accumulated debt there. So the question was that ECG didn't need this. How come that they bought something that they didn't need? Abro and Omobo Ghana. You don't need it, but you are buying it because all the stealing in this country is coming from procurement. That is why they steal. They inflate the numbers, things that we don't need, they buy them. So let me ask you, if it is your own business, will you do it like this? And people say, so we are doing ourselves abro. You see, what is the English name for abro? Those of you who are linguistic.
Abro is we are playing.
We are playing.
I'm trying to think of an English
cables
word
that we don't need.
Comes to mind
So,
quickly. I mean,
you bought.
it basically means that you are intentionally not doing the thing properly. You know the right thing.
That is sheer wickedness.
But it's deliberately.
That is sheer wickedness. So how can you be wicked and hate your own country and your own people like that? Things that you don't need. You use our poor resources. We don't have money. We are broke as a country. Every money that we are getting, we are borrowing. And you use the little money we have to buy cables and material we don't need. What kind of system is that? And you'll be surprised that these people will be allowed to walk through the streets of Nima and man will be free. They should go to jail. How do you do abroad like this to your own country? You are enemy of your own country. You bought 2,491 containers. And out of that 2,491, only 1,134 were accounted for. 1,347, which is more than the one that you accounted for, is missing.
I mean,
what kind of country are we living in?
I mean, Prof makes the point quite strongly about the fact that we are talking about containers. like not mobile phones or anything where we are all around the table. I can easily pick yours and put in my pocket and we now have to figure out who has taken it. More than 1,000 containers.
I can believe. This is. I mean, even if you watch this in a movie, you'll be surprised. And I don't know whether I've been asking myself. I can believe. When we're growing up, it's like Kokwananse's story is told in almost every house. Yeah. Right. And Kokwananse is always
very crafty
person.
Yeah.
It's always cheating.
Yeah.
Trying to. Could it be that the Kokwananse stories that were impacted to us at that early age has also affected the way people have become crafty when they grow, or they become crafty when they grow?
I mean, because Kwekwananse's conclusions were never good. He always ended up in trouble. Eventually. So that was the lesson from those stories.
I've been wondering. Containers. I've done businesses that have passed through the port before. So I've been there a couple of times, getting my containers out. But I'm telling you, what goes on there in terms of the difficulty with which you can you can get your containers out. And over 1,300 containers.
Yeah. Missing.
They
vanish into thin air.
And why should there be a situation where ECG would have that number of containers there when those items in the containers are supposed to be used for service delivery in terms of providing light for us?
In fact, the energy minister tells us that they actually imported more than they needed. So, I mean, basically those were things that, and even some of the containers, some were even sold to private individuals, and ECG bought them.
I mean,
at higher prices.
You see, let me tell you, the wickedness. This is sheer wickedness. This is not, I mean, to say this is corruption would be an understatement. This is more than corruption. That is why they would have to be dealt with severely. I mean, this is something when I hear the minister speak, I like his demeanor. He tries to be gentle and all that. The Minister of Energy.
Okay. John
Jinapo. I like the way his demeanor, he wants to be gentle. Yes, appear gentle, but let the law work to perfection in this matter. Because, but it also underscores some major lapses in our system. The fact that, and let me just digress a bit. The fact that somebody can transfer public money from public account to his private account and subsequently be using that money to do transactions without having any system to detect that, it's problematic. And to have a situation where people can get some of these containers out of the port, then the issue of our security architecture at the port and oversight mechanism at the port becomes. I mean,
I think what we know, what it tells us is that there definitely has to be a number of individuals involved in it.
It's a cartel.
I mean, because anything that is leaving the port, once it comes in, there'll be records of it.
Yeah.
Once it is leaving, you would have to show that it's been cleared to go as well. So all those.
There's a cartel there.
But Akable, it's difficult to wrap your mind around it because container stealing and foreigners involved, Chinese. I've been to China a couple of times. China, you can do this, a foreigner do this in China, you are dead. But they're able to do that because our people are so corrupt that when they come, they see the corruption all over the place, so they get involved. This issue, my brother, I'm telling you, every Ghanaian must follow this issue to its logical conclusion. And anyone who is found to have involved himself in a way to steal from the country should be dealt with, should be made to face the full force of the law. And people must go to jail. This one is not a matter of usually hiding behind rule of law to shield people. We should open up and allow the law to work. Let people, we need to know from the beginning to the end how the people are going to be jailed. We should know the process because this is serious. This is too much. And ECG, I believe, because I've heard, and usually I've seen some MPP guys throwing out there pictures of containers, flying containers with NDC colors, with John Jinapo's picture on the containers to suggest that these things happen during NDC time. But I've listened to two people, the national security person who spoke yesterday. He said these things started happening last year. Last year. So we need to ask questions. Who was the CEO of ECG at the time? Who was the board chairman or board members, or who were the board members at the time? No. Who was the Minister of Energy at the time? Heads must roll. We need to go back and rig all this debt and deal with them. Deal with them. So me, honestly, and also the issue, you see, I believe that if you look at the value chain management of the ECG, so the supply chain management of the ECG, certainly there's a problem. I mean, why should you be importing more than necessary? And why should you be importing and leave your containers at the port for years? Is it issue of causing financial loss to the state? You are the lawyers. Certainly, the law must apply, and people must, the heads must, so people must go to jail for this.
I mean, Mr. Maleba, I mean, it raises questions also about verification of some of the matters that came up during the transition process. Because at the time, the minister said that about 3,000 containers, almost 3,000 were stuck at the port. And now he says, okay, well, I think a committee should go and look into it. And it turns out that about more than 1,000 of them. So even people are even confused. Did the theft take place post the transition period, or it took place before? And people are even asking questions that maybe some of the claims that were made in those transition documents, some auditing of sorts should be taking place.
You know, the only species that has a capacity to reason is human beings, you know that. But we hardly use it. We don't use it most of the time. Else, if your head is firmly stuck to your neck, as a Ghanaian, you won't do what is happening. If you have your neck firmly, your head firmly stuck to your neck, no Ghanaian will do what they have done. And so for me, the good thing about this change of government is about to stop the rot. Because we all knew that under this under MPP, the rot was too much, but we didn't know the extent to which it was. But now see what is happening. Because like Prof said, if the MPP had continued to be in government, what we would have found out is that they will amass so much ill-gotten wealth such that our children will get up one day and say, we are useless.
Yeah, useless. Yeah.
We are, because you know what was going to happen? You know what was going to happen? They would have invested, and from their generation to the next generation, everybody will be sleeping in the house, but will be eaten. Then our children will be walking in the sun and be friends with them. And then they will say, oh, this was bought for my father. Then they will come back and ask you, when you were there, what were you doing? That was what was going to happen. Because people are filthy rich and they are still stealing. Some are stealing with their hands, some are stealing with their legs. They are collecting.
And they are still mad.
They are still taking. Look at the guy who they say he has how many houses in one place?
27.
Why?
27 houses.
Yeah.
Your hands in somebody's pocket. Stealing
I thought that stealing is because maybe, though not justifiable, you were in need. So now when you are balanced, you are okay, you stop. But some people...
I mean, what people will say is that they want to go 3 steps so that those coming after will also not have to have reason to want to steal.
So, what is happening is so serious. And look, if this were in China, somebody mentioned China, executions would have taken place.
They will kill you.
You are dead.
Executions would have taken place. So, I am not going the China way. I'm saying that let the laws work. Clearly, during the transition period, because you are not in charge, you will not know everything. And like our people will say, it's only when the frog dies that you see its full length. Now the frog is dead. Now they can see the extent of, pilfering that the MPP administration took us through. You see, to be honest with the MPP people, I beg them. I don't think that when Akufo-Addo was appointing the people, part of the appointment letter said that, and then steal the resources. So they should stop defending people who have gone to misbehave. There are a lot of them who have left out a government and nobody's talking about them because they have acquitted themselves. That is how they should see. I will not one day support the NDC person who has soiled his hands. I won't do that. So it is about Mother Ghana. They should stop defending people who have wreaked havoc to this country. And the advice is that let's all agree that for once, I agree with Asifwa when he said that about this housing thing. No?
So nobody should defend him.
Nobody should defend him. Yes, let him defend himself. Yeah. Because I don't think that there's a president who, after appointing, would then whisper to your ears that when you go, steal the resources where you are.
But the president must have systems in place to ensure.
But it looked like in the Akufo-Addo administration, it was like that. So everybody's stealing. Everybody's stealing.
I mean, I think all those are issues that the investigations, the Operation Recover All Routes and all those, the Attorney General's office, we know they is investigating a number of issues. They will be looking into it and we'll see how
it goes.
All of that go. And that is it by way of our discussion today. Just some update in terms of our reporter who was embedded in national security that undertook this operation. He makes the point that 12 Chinese and a Ghanaian are in the custody of the national security in connection with the missing containers at the Tema port. The suspects from 2 aluminium smelting companies located in Shai Hills were arrested in an intelligence operation on Thursday. The cables are believed to be part of the missing consignment that was traced to the aluminium smelter owned by these Chinese at the Shai Hills Game Reserve, where they are being melted into aluminium bars for export. And so we heard from the national security and the police who have been handling this particular matter. Another message that came in here, let me just quickly take you through that. But someone's also said that Abro is sabotage. The question earlier about what it is.
That's the word.
They said it's sabotage. And a message here from Fred Forson on our earlier conversation concerning the Chief Justice says, to my mind, the prima facie in 146 in respect of the President forwarding the petition initial determination is a very simple one. The Council of State is just to determine whether it meets the constitutional requirements. As Council Samsaladi explained, just first impression. It is not necessarily courtroom prima facie. And so that is it by way of our discussion this morning. Trust that we'll bring you updates on the various issues as and when there are developments with regards to that. But my guest this morning, you earlier heard from Samson Ladianyan, a legal practitioner. He joined us from the start in studio. Abraham Amaliba is a legal practitioner and also a member of the NDC and the Director General of the National Road Safety Authority. Next to him, Ebo Bachman, a senior communicator, Movement for Change, and also an economic and financial analyst, and Professor Inokopuku Entry, a governance analyst as well. My name is Joseph Akable. The show continues. Stay tuned in.
Every day, people have money emergencies. Ma, I need my school fees emergency. Mommy, chop money emergency. Emergency. Catch it. I'm in rent emergency. Now, there's a new emergency.
It's nice, but a double upgrade is amazing. And that's how we do it. Upgrade today to get even more with Step Up. If you're on GoTV Max and upgrade to GoTV Super, you'll get way more with GoTV Super Plus.
It's so cool!
Get big value. Get big entertainment.
Very good.
Perfect! Upgrade and get even more with GoTV. GoTV. Love it.
Hello, I am Ahmed Haidar. Today to speak about our company. We have all the products for the house and for the office. You have the living room,